government prior to real government, I was in charge of land deals and all this kind of stuff. And I drew up the deals. What I wanted to do is, we did transit, I wanted to go to each county. First of all, any liens in that county, IRS took, give those people the land back. And second, see how many, what people lost their land or houses from bankers and stuff like that. And work it out where we could trade some land, you know, on the same monetary value. Because there's a lot of land that like the veterans that they do serve all day. I mean, every year. What I'm talking about it. Well, we could take and figure out pieces of land in the same value, and we could get the land back in people's pockets.
Do you have those documents on the Public Texas website, or those of us from that?
Where do
The documents you were just reading from? Do you have that on the Republic of Texas
I
website?
can send it to you, but I don't have your, you give me your email.
Okay. No, this is
Your email's on the list, right?
Yeah.
You put it on the list?
Yeah.
I'll give it to you.
Okay, thanks.
Yeah, he's got it.
Well, if you want to display something right now, you have to plug. It ain't gonna hurt, I think, to plug the monitor they use. It'll reach there. We have to trade places.
Yep.
Is this your computer?
Are you seeing everything on my desktop now?
It looks like the TV is off.
Yeah.
There you go. So the monitor is on there. Well,
No
signal.
Oh.
Yeah, for a minute, till I find the document.
Okay, that's not going to be seen on Zoom.
But these guys can see it, right?
Yeah, we got a lot of people on Zoom, but we can see it. I don't know how we do that. Unless we plug in.
Yes, we are. So,
Yeah, she'd have to be on Zoom, we'd have to plug into it. Yeah. There you go. And then it would go back to Clint.
Oh, yes, actually, yeah, we could.
Yeah.
And you could go on Zoom.
Go on Zoom, then you can share with your screen.
And then it would be, no, that's still not.
Huh?
Yeah, yeah, because he'll have Zoom on over here.
You know how to get on Zoom?
No, it's okay, I don't need to. I'll try to make it brief and concise what we'll talk about today. I was gonna pull up a law brief, but, you know, I've actually got a printed version of it.
You're gonna have to talk into the mic.
Okay, can everybody hear me? Yeah, I don't mind if I start with prayer real quick. Heavenly Father, just please be with me while I present. May your will be done. I pray, dear Lord, that you'll live in our minds. May you bless us with opportunities to remedy our grievances. May your will be done. In Jesus' name I pray. Amen. I always need strength when I'm doing public speaking, so hope you don't mind if I pray first. I'm here to present the topic of suing judges, right? Because people, in general, are at a loss when a judge has injured them. And there are doctrines of judicial immunity that when you do sue, this immunity doctrine is going to come back at you as a defense. Now, you sue judges in federal court, and there's a couple ways to do it. You could go straight for the jugular, or you can perfect the case before you even go into court, which is the way I prefer to do it, where you win before you even walk through the court doors. And what you do is this. You draft an affidavit of truth, and in your affidavit of truth, you will have facts showing a constitutional injury. In other words, your affidavit is not going to say, my Fourth Amendment rights were violated. What is that? That is a conclusion of law, right? You can make that statement, but only if you have facts supporting that Fourth Amendment violation. So it's all about the facts. You have to be able to state facts in affidavit form. And here's what that would look like. On June 22nd, at 6:03 p.m. at night, I was pulled over with a police officer's lights behind my car. As he approached my car, I responded respectfully, yes, officer, how can I help you? He immediately ordered me to get out of my car and told me I was under arrest. I asked him if he had a search warrant. He said no. I asked him what his probable cause was. He said, I'm a police officer, I don't have to answer your questions. He further arrested me, took me to jail. I never knew why. He never answered my questions. I asked him multiple times, please explain why I'm being arrested. He would not answer me. My car was searched and seized and towed and held in impound for 25 days. I was told it would not be released. I was in jail. I had 3 magistrate hearings before the judge. I'm just throwing out a scenario. This didn't happen to me. I'm just saying. You're pleading facts showing, right? That's the standard under Federal Rules of Civil Procedure 8. Now, before we get our common law courts up and running, if you have an injury that's ongoing now, this is how you plead it, right? You would make statements of fact, just like I've time, states, places, events. And then you can add your labeled conclusion. I was searched and seized without a warrant. Of course, that's right in line with the Fourth Amendment wording, right? I was punished. I was not offered an opportunity to have a trial. Police officers came into the jail, pulled me into a separate room, and interrogated me without Miranda warnings. It's a Fifth Amendment violation. We have decisions from the U.S. Supreme Court on that, Miranda versus Arizona, Escobedo versus Illinois, other U.S. Supreme Court decisions that talk about how unconstitutional that is. We have open courts provision, right? That means we are not to have a dark trial by police officer in police officer contained jail facility. We have it in a courtroom with open to the public, open court's provision. That's where we meet our accusers, not in the jail cell, right? So when we plead fact showing, is again the standard, then you can come to your labeled conclusions. Because you see, the only immunity that can be pled in federal court by anybody is federal qualified immunity. It's the only one that they can plead. And the standard is very high to plead it, because you have to show that that Fourth Amendment right and that Fifth Amendment right not to face punishment before trial, because guess what jail time is? Punishment. You have to plead those facts showing the constitutional injury, and then state, oh, and the Fourth Amendment was clearly established at this time. What that does is it negates their opportunity to plead federal qualified immunity. They're going to plead judicial immunity. And what's interesting about that, which you've got, anytime there's ever a legislative codified statute immunizing one of the other branches, guess what that is? You've got a violation of the separation of powers doctrine, right? We do not have the ability from the legislative branch to immunize the judicial branch. Why? Because their powers are clearly defined in the Constitution. The legislators cannot broaden their own powers, and nor can they broaden the other powers of the other branches. So you can't have the legislature expand the powers of the executive branch, which is president, whoever's in office. You can't have the president expand his own powers by executive order or judicial decision. Their powers are separate, and they cannot extend more power to their own branch, and they cannot extend more power to any of the other two branches. So what that means is a lot of times these immunity doctrines are faulty because judicial immunity was derived by who? The judicial branch, trying to expand their own power, right? Is that possible? No, not underneath our Constitution. We have judges that wear more than one hat, right? When they are acting without jurisdiction, that's when they're vulnerable. That's the Achilles heel. So the question is, what is a judicial capacity? And what are the other capacities that they operate in? They also operate in a ministerial capacity. A ministerial or a clerical capacity is when they're operating from a statute. But if they enforce a statute that's unconstitutional, guess what? That's where they're vulnerable, because the judges are to catch the legislative oversights. For example, we have family code doctrines that are just ridiculously written by the legislator, not only in Texas but all over. The judge is supposed to catch that. The judge is supposed to be the standing guy to say, hey, I'm not operating from that particular statute because it's unconstitutional. It allows me to deprive a family of their family, children, without due process of law. I can't operate from that statute. You have statutory erroneous laws all over the penal code that infringe upon your Second Amendment right liberties, right? When a judge enforces that violation of your Second Amendment, guess what? That's what makes the judge liable for enforcement of an unconstitutional statute. Therefore, they're acting in a ministerial capacity. Therefore, they're vulnerable for suit. Here's the tricky thing about their judicial immunity doctrines that they would come back at you with if you ever filed a claim against them. Oh, judicial immunity. Well, they try to, just like they do all statutes, they try to over-apply or misapply a doctrine that doesn't apply. Gee, I know you're shocked, right? So if a judge just totally abuses someone without due process of law, what is due process? That's a good question, right? Due process is fundamental fairness. This is Fifth Amendment, and we also have it in the Texas Constitution right now, right? When we are dealing in their courts, they have this rule book that they have to play by. It's fundamental. Article 6 of the Constitution, right? Supremacy Clause. What does that mean? That means that the Constitution is the supreme law of the land. Supremacy Clause of Article 6 of the Constitution. Fifth Amendment to the Constitution is your due process. Due process is also found in your Texas Constitution. Why? Because every state is its own nation. It's found in Article 1, Section 19 of the Texas Constitution and your Fifth Amendment. Due process requires opportunity to be heard, opportunity to cross-examine your witnesses, opportunity to speak, opportunity to object, opportunity to put on evidence. And if that doesn't happen, guess what? Due process was deprived. So if you have a hearing where a judge tries to shut you up, and this happens, I know you're shocked, what do you say? What do you say if you're in a hearing and you are speaking on your own behalf and the judge says, "Sir, I don't want you to say one more word or I'm going to hold you in contempt." What can you do, right? Because that's very intimidating. Judges do that. So here's what you do. You say calmly, "For the record, I object," because that would be an unconstitutional act of the judge, and due process requires, Your Honor, that I give you notice that you are not authorized to do unconstitutional things from the bench, including blocking my free speech rights and blocking my due process rights, because I have the right, even in this courtroom that belongs to we the people, and that's found in Article 4, Section 4, an open courts provision, Article 1, Section 13 of the Texas Constitution. I have the right to speak freely, and your free speech rights are found in Texas Constitution 1.8 of the Texas Bill of Rights and the First Amendment. Your Honor, due process requires I give you notice that you cannot tell me to not speak. I understand that you have a duty to keep things calm and respectful and in order in this courtroom. Now, you can go on as long as you want to, but you have got a duty to object. And he says, "You're going to need to stop right now, sir. You sit down and don't say another word." Well, if I had, Your Honor, for the record, if I had had an opportunity to speak, here's what I would have said for the record. I was going to put the judge on notice that his order is unconstitutional because it violates due process and it violates my free speech rights. That way you're perfecting the objection. Because in the trial court, it's all about perfecting the record. Object to everything the judge does that you don't like. And I mean, you have a whole beautiful cornucopia of constitutional rights that you can pull out from. And I suggest every time that you can memorize it, both state and federal, because you never know when you're hauled into court against your will and you have to present yourself. You have to speak on your own behalf. And that's found in Texas Rules of Civil Procedure 7. Any interested party has the right to speak in their own case, or they can hire someone to speak on their behalf. So you need to know these things. And if the judge says, "I'm going to hold you in contempt," okay, Judge, I've got a quick question. Which contempt are you going to hold me in? He's going to look at you funny, like, "How dare you know about contemptuous things?" There's 3 different kinds of contempt, Your Honor. Which one? He may not even know that, right? They're not the brightest. It's okay. Maybe you can educate them. Well, Your Honor, is it coercive contempt that you're going to hold me in? Or is it constructive contempt? Or is it direct contempt? Which one is it? Which contempt are you going to hold me in? And the answer would be direct contempt, right? Because a judge with direct contempt, he's holding you accountable for doing something that's outrageous conduct in the courtroom, because he's got to keep things calm and moving along and following, rolling with the procedures. He may not even know what the different contemptuous things are, right? Well, Your Honor, free speech is not contemptuous. For the record, I'm going to object to you accusing me of being contemptuous, because I'm not. Speaking calmly in your courtroom, or our courtroom, always call it yours, but you're the boss, right? We're the people, they're the servants of the people, they're civil servants. We have the opportunity to present the evidence, say, okay, Your Honor, well, here's where I want to go next. Let's talk about this. I'm ready to put on my first witness, right? He's going to try to block you. He doesn't want your witnesses on the record. Anytime he does something that you disagree with, you've got to object, but you've got to know what to object or how to object, right? Fundamental fairness is due process. That's Fifth Amendment. To have an unbiased tribunal is found in the Sixth Amendment. To take the case out of the clutches of a judge that might want to hammer you because they don't like people that know the law, it might be wise for you to demand a jury trial of your peers. And that's your Seventh Amendment right. Contempt really is unconstitutional. Oh, let's go back to that real quick. Direct contempt is something that's done right in the eyes of the judge. That's direct contempt. That's really the only one that he's got. But especially when you ask him which contempt, Your Honor, there's three. Which one? Let him answer, right? Coercive contempt is another one that really is outrageous, but it happens. That's typically done when a man owes child support or a woman owes child support to the other spouse and won't pay, and they hold them in jail until they can pay. Well, it kind of makes no sense, because who can pay child support while they're in jail? But that's coercive contempt, and it's basically told, hey, you hold the keys to your own prison sentence. So as soon as you come up with that child support money, but that's coercive contempt. They're trying to coerce you into doing something. And a lot of times the correct answer in a child support case where someone has not enough money to pay the child support for whatever reason, the answer is, Your Honor, I'm not able to because I've been unemployed for 6 months. I'm not able to pay that child support. I'm going to hold you in contempt. Which contempt? Right? Okay, so that's coercive. Direct is done right in the eyes of the judge. And then there's constructive contempt. Now, the beautiful thing about constructive contempt is this. Constructive contempt happens outside the courtroom, right? This is where you got him, too. It completely requires due process of law, which means that the judge has to Mirandize you if you are a witness in that case. In other words, if it's an order that he thinks that you violated, right? And he wants to put you on the stand so you can answer, which don't do it. You have Fifth Amendment rights to keep your mouth shut, right? Don't give him the answers. You can say, this is direct contempt, right, Judge? Is that what you're trying to hold me in contempt for? Direct contempt? Something that happened outside the courtroom? Well, who's my accuser? You? Are you going to cross-examine me, Judge? Well, are you going to read me my Miranda rights, which is required of you? And if so, I have the right to remain silent. Anything I say can be used against me. I'm just going to say nothing. Your Honor, how about we put you on as a witness? I want to cross-examine you, Your Honor. I mean, it's Fifth Amendment. I'm the accused person. All of a sudden, I've got criminal accusations of contempt on me. Are you going to cross-examine me? Are you going to play prosecutor because you can't do that? Right? I'm going to cross-examine you. If this is a criminal trial, I have a right to put on witnesses in my favor. Which one is that? It's due process. I'm going to put you on the bench, or I'm going to put you in the jury box, or the witness box, Your Honor, and I'm going to cross-examine you. Right? Because you've got the right to do that. Ooh, that's a big shutdown, because it can't be judge and it can't be a witness in the same hearing, and that's Evidence Rule 605. Texas Rules of Evidence 605. They cannot speak and put facts into the record. That's another objection. If you're ever in a courtroom hearing and the judge is making factual statements, you're going to say, I object, Your Honor, under Evidence Rule 605. You are not allowed to speak factual things that are not in evidence. So I must warn you now, due process requires that I give you notice. You're not allowed to do that under Evidence Rule 605. That judge has to just keep his mouth shut. That's how it works. Okay, so we have a lot of things that came out of the 14th Amendment in the Civil Rights Act of 1871 that really holds these magistrates, it holds their feet to the fire. I've got a law brief here. It's a Yale Law Journal, and I can email this to you if you'd like. But it talks about the liability of judicial officers under 42 U.S.C. 1988. That came out of the Civil Rights Act of 1871. And because judges, when you're suing them under 1983, again, where is their Achilles heel? Where's their weakness? It's in the willful, intentional deprivation of your fundamental liberty. When you plead fact showing willful and intentional behavior on that judge's part, guess what? There's no judicial immunity because they're not acting in a judicial capacity. Why? Because a judicial capacity is a constitutional capacity. They have to honor the Constitution at all times. So there's all kinds of, when you read some of these decisions about judicial immunity and judicial capacity, there's two capacities, judicial capacity and ministerial capacity. Judicial capacity is only when they're acting inside the Constitution. In other words, they allow someone to completely have due process. They allow you to put on evidence, cross-examine witnesses, put on witnesses in your favor, and do everything you need to do. And then if your judge is the fact finder, that's the only time he can be acting in a judicial capacity, right? All right, is everybody with me? Ministerial capacities when they're acting underneath the statute, judicial capacities when they're acting under the Constitution. You'll see these decisions that are trickily written, and they're done that way for a reason, where it's talking about jurisdiction. What gives the judge jurisdiction? When they're following the Constitution, when they're following your rights to due process. We have a beautiful nugget here in Texas in our Constitution. It's very rich, and if you're not aware of it, I'm going to remind you, or maybe include this for the first time. It is Article 1, Section 29, Provisions of the Bill of Rights, excepted from powers of government to forever remain inviolate. Okay, this is not accepted with the ACC-EPTED. This is EXCEPTED. So this particular nugget of truth, Article 1, Section 29 of the Texas Bill of Rights, it says this: to guard against the transgressions of high powers herein delegated, we declare everything in this Bill of Rights, which is the Texas Bill of Rights, is accepted, again that's EXCEPTED, out of the general powers of government, and shall forever remain inviolate, and all laws contrary thereto or to the following provisions shall be void. This is what they do all the time. You have every single one.
Can you say that last sentence again?
Yes. You want me to read the whole thing again?
Just the last
The
sentence.
last ones. All laws contrary thereto or to the following provisions shall be void. In other words, we have void orders coming from our courts all the time. Why? Because due process was deprived. Because due process was denied. A right to a jury trial was denied. A right to put on witnesses. A right to cross-examine witnesses. Putting witnesses on in your favor. All that was denied. What does that mean? That means that whatever judgment that comes from that judge, it's a void judgment. So if a judge signs an order, criminally prosecutes or civilly prosecutes you, and due process was denied, fundamental fairness was denied, and so forth, it's a void order. And you just put a notice of void order into the record. You go file it. Notice of void order, and then you cite Article 1, Section 29. You can make it a one-page simple document where you're voiding it. Now, hopefully, if you ever go into court, you perfect your standing. You're going in there again. You're winning before you even go into the court is what I like to do. Make it easy for ourselves. We only have so much time in this world. We might as well just cut to the chase and win before we go in, right? You can do that by putting your affidavit of truth, and in those facts, plead facts showing. That's Federal Rules of Civil Procedure 8. Plead facts showing a constitutional injury. And it doesn't matter who did it. It doesn't matter if it's a police officer. There was the first 42 U.S.C. 1983 claim that came out. This was the Civil Rights Act that was passed in 1871. The first time that was ever enforced was, I guess, it had been hidden for a long time before somebody found it. And it was a guy out of Chicago that police came in, ransacked his apartment, destroyed his private property, rummaged through his drawers and tore his apartment apart. And he was the first one to sue, and it went to federal court, and it went to the U.S. Supreme Court. And this was 1966, a Monroe Pape decision. And it's a powerful decision because it says anybody that violates the Constitution, and the police that did this to the Monroe Pape decision, they didn't have a warrant. They seized, searched without a warrant. Guess what? Fourth Amendment violation, right? And then they put him in jail for a week or however long. We can go back and read that decision if I'm not up to it on my memory. When you plead, you will put in your affidavit of truth, I'm a living man, made in the image of God. You know what? This is where your jurisdiction comes from. You can also cite scripture, because you know what? It has already been recognized in the higher courts that the Bible is the law. Cite the Bible, right? Scripture says in Genesis 1:26 and 27 that God created men and women out of the dust of the ground, bit down, breathed the breath of life, and man became a living soul. Quote it. I'm created in the image of God. I am not chattel, property, a slave class citizen. I am not a dead baby. Guess what? The IRS manual, they call us infant decedents. That's a dead baby. This is the presumption that you're up against when you're going into their dead corporate courts, right? They're presuming you're dead too. Guess what? They've already incorporated your name, so they're just treating you as if you're a corporation. They have already copywritten your name over in the British Crown across the seas. They've incorporated your name the way you normally write it, with your first letter being capitalized, the rest being lowercase. So if you really want to go in and state your living status, do all lowercase. You can also sue in your all caps name if you want to, if you own and control it, right? If you've already gotten the common law title to your all caps name, then you can sue under that. You're operating in commerce. That's one way you can do it. But you have to control the straw man, right? You have to own him. He has to give you, your straw man has to give you a power of attorney to act on his behalf, right? Pretty easy. There's power of attorney forms. But it's wise to have that copy written too, right? That you're copywriting the name and not them. Because if they don't have proof that they've copywritten it and you do, guess who's going to trump that deal? You can say, hey, I copywritten this name. It's mine now. I roll with this. Here I am the living man, but I'm operating in commerce, so I'm going to also vindicate my rights through this corporation name if I need to. But I'm coming to you at both capacities. What are they going to do? When you sue a judicial officer, the federal courts are courts of limited jurisdiction. What does that mean?
Don't forget to subscribe to this YouTube channel. Don't forget to like this video. And don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. Here's the front page of the channel. The bottom arrow is pointing at the subscribe button that's normally red until you click on it, and this one turns white after you subscribe. And the right one is the arrow. the top arrow is pointing to the bell. Now, the bell doesn't show up until after you click the subscribe button, and then the bell will show up. And that way you can be notified of new uploads. Our blog is texasrepublic.wordpress.com. Our website is thetexasrepublic.com. Our email address is oneyellowroseenterprises@gmail.com. Our YouTube profile is, this is the link, because YouTube doesn't allow us to have a customized URL until we have over a certain number of subscribers. And follow us on Twitter at Texas Republic for You and at We Are Texians.
The United States as a co-plaintiff with you, right? Or you can sue the United States as the adverse party against you. But you got to put them on notice beforehand, which is why you always put that affidavit of truth. And in it, you're going to plead facts showing your constitutional injury, not just going to say, my Fourth Amendment rights were violated. My due process rights were violated. You have to plead facts showing how they were violated. And the more facts and details you have, the better off you are. If you've got dates, times, locations, the officer's name, his badge number, if you've done your open records request to glean maybe that judicial officer's his oath of office, it's powerful, right? And if you're going to go into federal court, you better know how to play the federal court games. Even though you don't have to, because you're not a bar member, you're not going to write pro se, you're going to put your name in all lowercase at the bottom of your pleadings, and you're going to sign your name, UCC 1-308, in other words, all rights reserved, I'm not waiving any of my rights. And in the area of your pleading where you would normally put original petition, you put original petition and jury trial demand, right? It's got to be right there, your first pleading. When you fill out the form, and of course you're always welcome to call me if you have questions about this, you would state why you're able to bring this particular injury to the federal court, not deal with it in the state court. Why? Judges, suing judges or state officials, the federal courts have original jurisdiction over these matters, and that's statutory. Underneath the admin codes, I could look it up for you. Under 28 U.S.C. 3002, Section 15 A and B, I want to read this to you if you're not already aware of it. What is it again, for those of you taking notes? 28 U.S.C. 3002, Section 15 A and B, and it says this: the United States means, this is underneath the definitions, the United States means a federal corporation. Did you know that? Those two words, United States, means a federal corporation. It's right there. And then B is an agency, department, commission, board, or other entity of the United States, or an instrumentality of the United States. Well, you know what? You can bring the United States in with you as a co-plaintiff. In other words, it can be United States and Susie Smith, which would be your name, right? Tom Jones, versus Officer Cantwell, right? Officer Joe Cantwell, Sheriff's Office, blah, blah, blah. Whoever it is you're suing. So you can actually bring in the United States with you. You just simply need to put the United States on notice. You've got to put an affidavit of truth in their hands to say, oh, by the way, I'm adding you on as a co-plaintiff because of my injury. You have a right to do that. Whenever you're putting your facts together, you're pleading in your affidavit of truth, you should also, after you plead your facts and you state which constitutional amendment they violated, say this: my Fourth Amendment rights were clearly established at the time. Therefore, Joe Cantwell cannot plead federal qualified immunity, and that's the only immunity that can be pled in federal court. his acts, because they were willful and intentional, and hopefully your facts show that, right? Because his actions were willful and intentional, it makes it a violation of federal penal code law under 18 U.S.C. 242. And so your facts could be something like this. And after he searched my car, and after Judge so-and-so deprived me of bail for 30 days, when I was entitled to bail after 24 hours, I was denied bail for 30 days. They held me with no bail. Well, guess what? You've got the right in both the federal criminal or the federal code of criminal procedure. You have that underneath the state codes. You have that in the Constitution. Where is it found? Where's your right to bail? 8th Amendment, right? And the bail has to be reasonable. What is reasonable, right? What might be affordable to you might not be affordable to me. You know, rich man Ed over here who might make $500,000 a year and I make $20,000 a year, bail for him might be affordable at $5,000. Well, $50 might be affordable for me. So how is that judge going to know if that bail is affordable? Well, that judge in a bail hearing, he's got to ask, right? He's got to ask, sir, can you afford this? You say, no, officer, I only make $20,000 a year. How can I afford that? Barely feed myself and my family, $20,000 a year. How can I afford that? I can afford $10, sir. Is that good enough for you? That's all I can afford. He's got to set reasonable bail. What's reasonable for one person might not be reasonable for the next. What does a judge have to prove in a bail setting hearing, right? Because it's not that high dollar amount bail is not about punishing you with a high economic burden. It's about securing that you will come to trial, right? So he's got to prove that you're a flight risk. He's got to prove, oh, this vagrant guy, he's sleeping on, 25 different couches in 30 different days, and, he has no home, and he has no wife or family, and no family ties. Those are all things that would set bail high. But, the contrast would be this guy owns a brick and mortar home. He's lived in that home 20 years. He's worked with the same employer for 10 years. He's happily married. He's got 5 kids. Guess what? The fact is a person like that is likely going to show up for trial, right? And all this is also in their federal criminal codes too, or federal codes of criminal procedure. That is how they're supposed to set bail, is the likelihood that you're going to show up is not to be used as punishment economically. But guess what? That doesn't happen, does it? No, they deny bail all the time. They don't ask if it's reasonable. They set bail too high because judges abuse their power. So if you have an attorney in that situation, which I would not recommend somebody hire an attorney, but you need to know this, right? In a bail setting hearing, this is something you need to know if you're speaking on your own behalf. Your Honor, I live in a brick and mortar home. Your Honor, I've been working for the same employer for 25 years. Your Honor, I've lived in my home 13 years, right? I've got a husband or a wife. I've got 5 kids. I'll show up for trial. Just let me go. Set the bail now. It's got to be reasonable. All I can afford is $20. Here you go. That's what they have to do. Okay, so if they don't do it, guess what? There's a Texas Code of Criminal Procedure that also requires them to follow that statute, both constitutional and statutory. So they have got to set bail. It's got to be done within 24 hours. So when they don't follow the rules, the question you would do in front of a judge, you would speak on your own behalf. You would say, Your Honor, and what statute are you operating under? Can we read it into the record? And he might say, it's my discretion. I can do what I want. Really? Where is it giving you discretion to violate the Constitution? Because we just read Article 1, Section 29. This is your magic silver bullet, right? This one says, all laws contrary thereto, talking about the Constitution, the following provisions shall be void. If it's contrary, if it's a statute contrary to the Constitution, it's void. Right now, we have some outrageous conduct by our state officials enforcing what? Unconstitutional violations of commerce. Where's our Commerce Clause found? Does anybody know? Article 1, Section 9, is that where it is, or is it Section 10? Do we know the articles in addition to the amendments? Article 1. Article 1 is talking about commerce. Article 1, let's see, what does Section 9
Is that
say?
U.S. or Texas, I'm sorry? Is that U.S. or Texas?
U.S.
US.
Yes, Article 1. Article 1 is at Section 10. No state shall enter into a treaty, alliance, confederation, grant letters of marque, reprisal, coin money, emit bills of credit, or make anything but gold and silver coin to tender payments for debts, pass any bill of attainder, ex post facto law, or laws impairing the obligations of contracts. Powerful. Any title of nobility. No state shall, without the consent of Congress, lay or impose duties, imports, exports. Oh, wait a minute. Isn't that what we're doing now? What may be absolutely necessary for the executing of its inspection laws and the net produce and duties and imposts laid by the state or importers or exporters shall be for the use of the Treasury of the United States, subject to the revision and control of Congress. No state shall, without the consent of Congress, lay duty to tonnage, keep troops, ships, wartime or peace, and enter into any agreement or compact with another state or with a foreign power to engage in war. Unless invaded or in imminent danger, this will not admit delay. We have right now this commerce problem with supposed COVID that is supposed to be a bunch of bugs that are crawling around making everybody sick, right? That's the rumor. I don't know anybody sick. I don't know any hospitals full. And I know hospitals are bonused lots of money to label any death, even if you're hit by a bus or in a car accident. They're bonused money to label it a COVID death. Wow. Seems like the numbers are a little skewed, aren't they? The reality is different from what we're told in the news. So, it's a violation of, look up the Sherman Act and the Clayton Act. The Sherman Act is the act of commerce and invading the commerce. And I think the Clayton is the intrastate and the Sherman is the interstate laws that protect the ability to do commerce and to conduct business. And so there are penal code laws in the federal criminal code book that they are violating right now by invading commerce and stopping commerce. And you have Dan Patrick, who in Texas needs to be removed from office yesterday. I saw him on the news on Thursday, and he had the audacity to talk about Ms. Shelley. Is it Shelley? What is her last name?
Salon owner?
Salon owner. Is it Shelley? Anyway, sweet lady stood up for her liberty, went to jail, and Dan Patrick gets up on the news and said, "Oh, I was willing to go to jail for her. I mean, we don't really want people to go to jail. Well, I think she should just have to pay a fine." Really, Dan Patrick? You just told us who you are. That you are totally invested in violating our rights, because why the heck should somebody have to pay a fine to do what God has given her to do? To use her life energy to support herself and her family, right? And to be a blessing to the community. People need their haircuts. Sorry, that's an essential business in my opinion, right? I know people in the room need their haircut, right? We don't want to talk about anybody that's sitting right next to me. But who gets to say what business is essential? Every business is essential, right? Because it's a way that you use life energy. Who gets the fruit of that life energy? Hopefully God is benefiting from your life energy that you're using. That life energy to be an honor to the King, the Creator who made you, as well as to your family and your fellow men. We are right now, whether you like it or not, we are in a war. It's a war to invade you of your right to produce fruits of your labor so you can support your family, right? Who has the right to do that? First of all, we don't make governors lawmakers. They're not lawmakers. What does it say? Even if they were lawmakers, even if this were done by the legislature, even if it was done by a president, or even if it was done by a Dallas judge, what does it say in Article 1, Section 29? Now remember, judges have an oath of office, both federally, under Article 6, Supremacy Clause, they sign an oath. In Texas Constitution 16.1, they also have a written, sworn oath to take office, that they will uphold the Constitution. So when they're acting contrary to the Constitution, what are they doing? They're acting without jurisdiction. When they act without jurisdiction, that's what? That's their Achilles heel. They can be sued civilly for the injuries that they're causing you. Where in the Texas Constitution does it allow you to redress your grievances? Does anybody know? Article 1, Section 27 in your Texas Bill of Rights. Let's read it. Oh, it's a beautifully written one. It's even richer than the First Amendment. It's so good. The right of assembly, petition for redress of grievances. The citizens shall have the right in a peaceable manner to assemble together for their common good and apply those invested with the powers of government for redress of grievances or other purposes by petition, to address, or remonstrance. Can we remember that? Article 1, Section 27. Now, what they're doing right now by stopping commerce, it's going to have some ripple effects. And one of them is going to be this. It's creating of monopolies, right? Because the little companies, the little mom and pop businesses that employ the majority of the people in this country are being put out of business. Why? Because it's those smaller corporations that don't have a lot of bankroll, where you have big companies like Amazon or Walmart or Costco or Sam, whatever. Those bigger companies are going to be able to survive this mess. So what we're going to see are monopolies coming out of this. Here, do you know where the anti-monopoly clause is in the Texas Constitution? Article 1, Section 26. Let me read it to you. Perpetuities and monopolies and primogeniture or entailments. Perpetuities and monopolies are contrary to the genius of free government and shall never be allowed. Oh, does it say never or sometimes? I like the word-by-word version of how it's written. It says never be allowed. What? Let's go back and read that again. I'm confused. Let me reread it. How can this be? Monopolies are contrary to the genius of free government and shall never be allowed, nor shall the law of primogeniture or entailments ever be enforced in this state. If you look up those words, primogeniture, P-R-I-M-O, G-E-N-I-T-U-R-E, I believe that that's talking about people that have relatives, if you're only doing business with those relatives. I think so. You can look up the word.
No, that means,
Will, and that goes to the first.
Oh,
Yeah,
yes, that's it. No, it's the entailments that I'm talking about. You're right. Yes. Primogeniture. I got it confused. It's the entailments. I think that you're just doing business with family. But when monopolies are being created, which is what we're seeing from this, because it's going to cut out all the little small businesses, the ones that employ the majority of your fellow Texas men and women here in the state, they're going to be unemployed. Those little mom and pop shops cannot handle it when they're being thrown in jail or fined ridiculous amounts of money for what? Just doing business? That invades what? The Commerce Clause. It invades the Sherman Act, the Clayton Act. They're not allowed to do it. Why? Because it's withheld from all powers of government. Article 1, Section 29. It's powerful tools for your toolkit. Your toolkit's right here, right? Memorize this stuff. Also, another place where, well, you know, like we think about this lady, the salon owner. You're right, yeah. She's a victim of a crime, isn't she? Why? Because void orders from a judge acting unconstitutionally, she is a victim of a crime. Well, where's the crime victim's compensation? Did you know that that's also in the Texas Constitution? Article 1, Section 30 and 31. There's a crime victim fund that can be drained. Article 1, Section 30 and 31. She's a crime victim. Victims of crimes. Well, Article 1, Section 22. Treason against the United States shall consist in levying war against it. Well, when you're trying to crash the economy, that's treason. Sorry, Governor Abbott, Ken Patrick. What's his name? Yes. What is it?
Paxton?
Well, Paxton, but the guy that I was just talking about, I forgot his name now.
Dave Patrick?
Yeah, Dan Patrick, that's his name. It's treason. Sorry, Dan Patrick and Governor Abbott, but it's treason. Hey, you know what? Mayors don't have lawmaking authority. So when you walk into Home Depot and Lowe's and it says you've got to stand 6 feet apart from your fellow man and only 10 people can be in the store at the time, again, a lot of this, it feels like a test on how we're going to respond to these actions. And they're hoping that we're all stupid enough that we don't know what our liberties are, right? Well, you know what? Some of us are kind of well studied, and God has taken us through some storms where we are learning it and we are memorizing it. We weren't taught it in school. We had to self-educate, right? I've sued 5 judges in federal court. They know me, right?
It's fixing to be 6.
Did you raised your hand, sir?
I do.
What was your question?
I was going to say monopoly was on questions as observation. Monopolization will happen, or may very well try to happen, or be a byproduct of what they did. But make no mistake, their objective for doing that is not monopolization. Their objective is to make more and more people dependent on the government.
Yes, I agree.
And there's a huge segment of our government and our leaders that they don't like it when everybody has a job, when everybody's working, everybody's happy, everybody's self-sufficient. They want people dependent on them.
Because that's control.
And that's what they're doing.
Because that's control.
That's exactly what they're doing.
Yes. And if the people on Zoom did not hear, he was just explaining that what's going on now is not just the creation of monopolies, but also about government control for those who can't hear and hear in the audience. We also have an ex post facto law, right? Those are passed all the time. What's an ex post facto law? That means what is illegal today, you're being prosecuted when it was legal when you did it. You know, like, I can give you a million examples. Let's say somebody builds a house in 1980, and all of a sudden the city comes in and tries to condemn your house and says, well, your 1980 home is not up to current codes. And you're like, well, it was built to code in 1980. That would be trying to enforce an ex post facto law, right? We can't do that. Where is that found? Well, that's found in Article 1, Section 16. In addition, it says that there will be no retroactive laws or any laws impairing the obligations of a contract. Guess who has the right to contract? Men and women. You can contract with a corporation. The men and women have a right to contract with whomever they please. You do not have to enter into a contract with a court. You can tell the court, sorry, I don't want to contract with you. Sorry, there's nothing you can do to help me. I'm not going to step foot in your satanic courts because I'm a lover of God. And I want a righteous judge. I want one that follows my liberty given to me by God. Right? That's laid out in our Constitution. I love this because the founders of our nation were liberty lovers. This was a small group of people that wanted freedom from the most oppressive and powerful country that existed at the time, right? The UK, United Kingdom. They wanted freedom and liberty. How'd they get it? They left, they had to fight a bloody war, but they won because God was with them. God was on their side. God wants us to be free. I do not want my brothers and sisters to be enslaved. And I hear these words, God funnels them into my head all the time. And, sometimes I'm like, okay, God, I get it. He says, let my people go. Let my people go. Constantly funneling into my mind. Let my people go. Where did those words come in Scripture, right? God told Moses to tell that to Pharaoh. Let my people go. Those people have been enslaved for 400 years, building pyramids for Pharaoh. They didn't have a chance to worship God. They were working 7 days a week. They had no opportunity to worship their
Check out our other videos and playlists. Republic of Texas RT documentary. Texas and other American states is under a military occupation. The Republic of Texas Forum of 2016. And describe the kind of people who would thrive in independent Texas. And so check them out.
To worship their Creator. They had lost this righteous heritage, right? Abraham, Jacob, Isaac. Well, they got free, didn't they? God allowed the circumstances to get them out of Egypt and set them free. Here's what our founding fathers said in the Declaration of Independence. We hold these truths to be self-evident, that all men, not just some, all, that includes women, just saying, okay? All men, black, white, brown, Asian, any man, any woman, you're created in the image of God. And among these, okay, hold on, let me go back. All men are created equal, and they are endowed by their Creator. Who? Judge? President? Legislator? No. Policeman? No. Your rights come from your God who made you. He's the one that has jurisdiction. With certain unalienable rights. What does unalienable mean? You cannot be separated from them, right? Unless there's a contract. You can always agree to waive your rights by contract. Did you know that? But you have to do it willfully and knowingly. Otherwise, if it's deceptively written where they're having a document put in front of you in Chinese telling you to sign it and you don't know what you're signing, well, how could you say I understood what I was signing? I don't read Chinese, nor do I write it. But among these are life, liberty, and pursuit of happiness. And to secure these rights, governments are instituted. One of the beautiful things in the Texas Constitution, in Article 1, Section 2, is also very powerful. We've got to know these nuggets of truth. We've got to have this stuff memorized. Here it is, Article 1, Section 2. This sets the foundation for our argument in any court. Inherent political power is a Republican form of government. All political power is inherent in the people. Who? Your judge? Your police officer? No, in the people. Right? All political power is inherent in the people, and all free governments are founded on their authority. Who said there? The people's authority. And instituted for their benefit. Whose benefit? The people's benefit. The faith of the people of Texas stands pledged to the preservation of a Republican form of government and subject to this limitation only. They have at all times the inalienable right to alter, reform, or abolish their government in such manner as they may think expedient quickly. So what happens if a judge is enforcing an unconstitutional statute on you? You say, I'm sorry, I'm going to go ahead and alter that statute right now because it's unconstitutional. Do you have the right to do that? Say, yeah, I have the rights right here in Article 1, Section 2 of the Texas Bill of Rights. I have the right to alter, abolish, or reform an abuse of power of government right here. Abolish their government in such manner as they think expedient. You have the right to do it. You have the right to make those changes. We have the right to come together today and make changes because you know what we have is dysfunctional. It's abusive, it's oppressive, it's harmful, and people are being injured. And they are our brothers and sisters, and we want people free. So I hope, I don't want to take the whole day because we also have another speaker that I want to get to speak briefly on the Constitution. Yes, sir. Did you have a question?
The Republic of Texas Constitution. Hello.
The volume's turned down on it.
Number 2.
Yes.
Hello.
Wait. We're watching you play cards.
Go ahead.
Where's the other microphone?
The Republic of Texas Constitution the Republic of Texas Constitution, the delegation of rights is on the bottom of the Constitution. Why, when they created the state of Texas as a corporation, they moved those rights to the top of the Constitution and call it the Bill of Rights.
Mm-hmm.
What's your opinion on that?
Why did they do it? I can't answer why they did it. Other than there's a lot of funky things that I cannot answer why what's going on is happening.
Where does the judge sign a piece of paper?
At the bottom.
At the bottom.
Huh?
At the bottom.
Yeah. Okay, our Declaration of Rights used to be at the bottom. The people were sovereign, they control what was above it.
Yeah.
So
Well-
they moved it to the top where they can control the slaves.
The best thing that you can do when you're suing, you sue under 42 U.S.C. 1983 until we get our common law courts up and running. Can I read it to you real quick? 42 U.S.C. with U.S. Code 1983. Every person who under color of any statute, ordinance, regulation, custom, usage of any state or territory or the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to a deprivation of the rights, privileges, or immunities secured by the constitutional laws shall be liable to the party injured in an action at law, suit, or in equity, or other proper proceeding for redress, except that in any action brought against a judicial officer for the act or omission taken in the judicial capacity. What is judicial capacity? That's when they are honoring the Constitution, right? That means that due process has to be followed. Injunctive relief shall not be granted unless declaratory decree was violated or declaratory relief is unavailable. One of the fastest ways to win before you even enter into a courthouse is to do your affidavit of truth under penalty of perjury, sign a witness by a notary, and you send it to them. You give them notice and opportunity to respond. This is all done before you even file a lawsuit. You put in your facts. Again, the standard is fact showing. Fact showing your constitutional injury in an affidavit of form, swearing under penalty of perjury. I am of age. I'm over 18. I'm of a sound mental state. I'm able to make these following statements based on factual knowledge that I have. And then you list them out, 1, 2, 3. And the more simple that you make them, the more concise and less wordy. Because I know a lot of times when we do our own pleadings, we can be overly wordy. And I'm speaking the choir. These women are really good at just putting way too many words on paper. Simple is best. Fast, simple, and to the point. And make it as short as you can. Sometimes that affidavit of truth might be 40 pages because so many facts took place. So many injuring parties were involved. But put that affidavit of facts on the table. If you're suing a state official and you're suing underneath the Texas Tort Claims Act, which is, you can do that. It's a long way to do it, but before you sue them, you have to give them an opportunity. It's called a preservation letter, and you need to do it within 6 months of that injury. So if you've had an injury in July, my goodness, you need to send that notice under the Texas Tort Claims Act, Chapter 101, to that state official or that county or whomever it is, and do a preservation letter, and it would sound something like this, and you'd send it to a county or a city or that official. Dear Ken Paxton, right? I am putting you on notice right now that I was injured in this state by this state official by the name of fill in the blank. At this time, at this date, I need all records preserved because I am considering suing. I'm considering my rights to redress my grievances under Article 1, Section 27, because these acts were void and unenforceable, yet they happened anyway, and I'm injured. I'm a crime victim under, we already talked about that, right? Article 1, Section 30 and 31, you're a crime victim. They have a victim's fund. They can pay the claim. They insure these guys with a bond, right? You can do is, you can say, I need all records, video, email, phone records, preserved. You got to send that notice of preservation letter, send it, return receipt, registered mail, if you're going to sue under the Texas Tort Claims Act, Chapter 101. Because when you take it into federal court, they're going to say you don't have standing if you haven't already done that. You didn't send out your preservation documents, letter. If you need help drafting those, you're of course welcome to call me at any time. I'm happy to help.
And that has to be done within 6 months?
Within 6 months of the injury.
So if it's past that?
Like if you have an ongoing injury, or if it's after the fact, then you would challenge, you just sue directly under the First Amendment, which you can do. I mean, there's ways. Remember, statutes can be found unconstitutional if they're in conflict with your First Amendment rights to redress your grievances in Texas Constitution 1.27. If, for example, if there's a statute of limitations that they're trying to block you based on the statute of limitations, well, you challenge that statute of limitations is unconstitutional because it's in direct violation of the First Amendment in Texas Constitution 1.27. It's void and unenforceable, and they can't enforce an unconstitutional statute that deprives you of your opportunity to redress your grievances. I mean, you just challenge the statute of limitations. You challenge if they try to do a doctrine that immunizes one of these tortfeasors that violates due process, right? They deprive you of a civil trial, right? Texas Constitution 1.15. You've got civil trial rights in part of the Bill of Rights. Texas Constitution 1, Article 1, Section 15. I call it 1.15. So you can always have a trial by jury underneath both Texas and U.S. Constitution. There's somebody that came to me this week and, they were told by an attorney, oh yeah, you don't get a jury trial in civil matters. I'm like, really? An attorney told you that? Do they not know? I mean, you get it in most civil and criminal matters. Sorry. Attorney doesn't know their stuff. It happens.
A question.
Sure.
If you request a 12-man or woman jury,
Right.
do they have to give it to you?
Absolutely. You have to demand it. Don't request it, demand it.
Well,
Jury demand.
right. I demanded it, and they wouldn't give me the 6 people,
Okay. Well,
and I was just wondering about that. I kind of,
and you also have the right to have a jury trial of your peers. So who are the people that are like you, right? If you're, let's say you're a farmer, well, you want other farmers to hear your claim. Or if you're a baseball player, you want other baseball players to hear your claim. Why? Because they might understand your world, where you're coming from. Other baseball players, other realtors, other... Yes, sir.
I have a question. Have you ever heard of a tribunal?
Yeah.
And what forms of tribunals are requested, and how many people are requested of the tribunal?
Well, a tribunal is, my understanding is that it's a court hearing, right? So,
Judge alone.
judge alone? Well, you can always demand the fact finders be German. jury?
Yeah, it's, judge can, they do it all the time. If you don't have a jury, it is a trial by judge.
Right. You have to demand your jury.
Right. Tribunal sometimes is sometimes I've had IRS do a tribunal, which was tribunal 3. And so that's why I asked, when I get some of the details on that. But yes, jury. I'm doing the Bible. Paul in Acts chapter, Peter in Acts chapter 10, he did have 6. So, but I don't know under the statutes and the constitutions of the judiciary governments, they require different things. But I do know judges do trial by judge. If not, they'll do the juries of 12. They're very manipulated when it comes to the 12 jury. They tell the jury what they can look at and what they can't look at a lot of times. If you don't have an attorney there and some of those precincts that can object to certain things. But I've seen them where they manipulate the judges, the juries on what is permissible and what is not.
Yes. It is going to be the automatic default position that you're going to get a judge trial unless you demand a jury. So that is your 7th Amendment right. And under Texas Constitution 1.15. And, judges are notorious for, and here it is under the Texas Constitution, the right to trial by jury shall remain inviolate. Oh, wow, that's the same language we saw in Article 1, Section 29, inviolate. The legislature shall pass such laws as may be needed to regulate the same and to maintain its purity and efficiency, provided that the legislature may provide for the temporary commitment for observation and or, this is the part I need to challenge this. This is jacked up. This is in Article 1, Section 15. Listen to what it says. This needs to be challenged big time. Provided that the legislature may provide for temporary commitment for observation and treatment of mentally ill persons not charged with any criminal offense for a period of time not to exceed 90 days by an order of the county court without the necessity of a trial by jury. Wow, really? That's in our Texas Bill of Rights. That needs to be challenged as unconstitutional because it looks like, it looks like genocide. They're doing human experiments. They're going to observe you for what? A human experiment? For 90 days? Really? Detention for 90 days without a trial, without due process. That needs to be challenged as unconstitutional. Sometimes when the legislature wants to amend the Texas Constitution, they will have the most trickily worded questions added to the voter registration cards.
Not sometimes, all the time.
Yeah, where you think when you say yes, that you're voting for it one way, and really you're voting just the opposite way. So if you are a voter, I'm not, but if you are, you need to really read that wording. And this is jacked up right here. Because people that have mental defects, it would be no different from somebody with other defects, including a physical handicap or a malady that's going wrong with their body. They could have heart failure, right? Or they could be wearing a prosthesis. Does that mean that a mental defective person is more subject to detention for 90 days without due process of law? No, I'm sorry. That doesn't work. That doesn't fly with the Constitution. And remember, when Texas joined the Union, it had already seceded from Mexico in 1836, joined the Union in 1845. That was done with international treaty law, because you had Texas was its own nation, right? Still is. But when it joined the U.S., what happened? They signed a treaty. What's a treaty? It's a contract, right? We can see this in Article 1, Section 1 of the Texas Constitution, freedom and sovereignty of the state. Texas is a free and independent state. Y'all agree with that? Yeah. Subject only to the Constitution of the United States. Well, that's a really solid document, right? and the maintenance of our free institutions and the perpetuity of the Union depend upon the preservation of the right of local self-government, unimpaired to all states. So we've got this liberty where Texas is a sovereign state that has to bow and curtsy at minimum to the U.S. Constitution. Now, when you look at the U.S. Constitution Bill of Rights, it's the lean. It's the lean one. It's the floor. It's not the ceiling. In the states' rights constitution, it can be richer. The states are required to even offer richer rights. And I can give you an example if you'll bear with me. Just give me a moment. Underneath your free speech rights, I'm going to read the contrast between the state of Texas free speech rights and the First Amendment. Can I do that? Grant me just a little bit more time. I know you guys are, many of you might be tired of hearing my voice talk so long. Okay, here we have it in the First Amendment. Find it in my handy-dandy pocket, Constitution. It's all highlighted and underlined. Ooh, I love my Constitution. Love my liberty. Here we go. First Amendment. Very short and sweet, right? It has 4 prongs to it. Do we know what they all are? You guys got to memorize this stuff. Because when you're taken into their fraud courts, at minimum, they have to honor this, right? 4 prongs in the First Amendment. Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof. So that's the first prong, is religion. And abridging the freedom of speech, or abridging the freedom of speech. That's the second prong, get to speak. Or the press, or the right of the people to peaceably assemble. Is that being attacked right now? Peaceable assembly? And the petition of the government for redress of grievances. I call that the star in the constellation of the constitutional rights, is your right to redress grievances. So all 4 of those prongs are found power-packed in the First Amendment. Your right to religion, your right to free speech, your right of assembly, and your right to redress your grievances. Yes, sir.
But nobody has been able to redress their grievances through the Supreme Court.
Exactly. Because now it's not an appellate court. Supposedly they changed that. And a lot of people are going and living with ongoing injuries because the U.S. Supreme Court only sees 1% of the cases that come before them, and they're usually crafted by very popular, locally living lawyers in D.C. who know the judges and practice before them, and they have the little good old boy club. But there are other venues. Because it's international treaty violation, you could take it to The Hague. It might be harder to do. The Hague can hear some of this stuff, these international war crimes. Did you know it's an international war crime when they violate your fundamental liberty, right? That liberty is given you by God. It's an international treaty violation. Why? Because when Texas joined the Union, it was done by treaty. It was an international treaty. You had one nation join another nation.
What's it called? The Treaty of what?
Well, the annexation of Texas. Yeah. So when it joined the Union, that's two separate entities joining together under international treaty. What makes it international? They're 2 separate countries joining together under a union umbrella contract. And so you've got an international, I call it a war crime, especially if it's invading your fundamental liberties. So you can go into the Federal Criminal Code. Anytime you see 28 U.S.C., right, those are the admin codes of the Federal Code Book. 18 U.S.C. are the Federal Criminal Codes, or Criminal Procedure Codes. They're found in the 18s. And then the 42s are your Civil Rights Codes. Came out of the Civil Rights Act of 1866, 1871, 1873, 1875.
Reconstruction.
Yeah, Reconstruction. Here's one of the things we just read. I want to read this one to you. This is 42 U.S.C. 1988. And I have a brief. I can email this if you want to compile it's a very power-packed brief, and it talks a lot about U.S. Supreme Court decisions and how judges are liable in federal court, underneath this precious code, write this down, it's valuable. It's 42 USC 1988, and it came out of the Civil Rights Act of 1871. It says, applicability of statutory and common law. That sound familiar? We love common law, right? We want common law courts. The jurisdiction in civil and criminal matters conferred on the district courts by the provisions of Titles 13, 24, 70 of the revised statutes for the protection of all persons in the United States in their civil rights and for their vindication shall be exercised and enforced in conformity with the laws of the United States, so far as such laws are suitable to carry the same into effect, but in all cases where they are not adapted to the object or the deficient in the provisions necessary to furnish suitable remedies and punish offenses against the law, the common law, as modified and changed by the Constitution, and the statutes of the state wherein the court having jurisdiction of such criminal cause is held, so far as the same is not inconsistent with the constitutional laws